thank you again, Josh and Philip for joining, and glad you could take the time to do that. If you could please just introduce yourselves for those who might not know you. Josh, perhaps you could kick us off.
Hi, hope everyone's doing well. Thanks for having me. I'm Josh Klayman. I'm U.S. Head of FinTech and Head of Blockchain and Digital Assets at Linklaters, which is a global law firm. And I'm also one of our global tech sector co-heads. Outside of the office, I also chair the legal working group of the Wall Street Blockchain Alliance, and I'm on its board. And I'm on the board of Wharton's Cipher Accelerator. So I'm very passionate about this space.
Awesome.
Oh, and I'm based in New York.
Right on. Well, and Philip, how about you?
Yeah, so I'm Vice President of Legal Affairs and Assistant General Counsel for JP Morgan Chase and Company. And prior to that, I've worked at several law firms doing international work in the private funds and private investment space that touch on everything from real estate to energy to everything under the sun. And that would include investments in the digital assets, cryptocurrency space using blockchain. Published several articles about the intersection between legal affairs, regulatory interests, and the applications of blockchain technology in business and industry. And as Josh said, we're very happy to be here. I'm looking forward to a conversation.
Excellent. Yeah, glad you can join. Right on. And then just to briefly introduce myself, so I'm David Doss, and I'm the founder of CKC.Fund. And we're pleased to be sponsoring Digital Davos with this seminar and the events in Cayman that are also happening today. Thanks to Carl at ChainBLX for organizing this. And in terms of my background briefly, so I have spent about the last 6+ years in the blockchain and cryptocurrency space. So, I mean, for an emerging asset class, that's a solid while here. Worked on blockchain and crypto initiatives with Citibank, Gemini, and various other players, great and small, in the space. And currently leading CKC.Fund, which is a fund advisor operator focused on digital assets. So with that, yeah, glad that we have two lawyers in this talk about crypto and the SEC, because it's I think a fairly nuanced topic that a lot of people have opinions on, but I think it's also good to have some informed opinions from a legal perspective here. So to kick things off, maybe we can start with Philip. What do you think are some of the key concerns that the SEC has regarding the regulation of cryptocurrencies and how they might impact the industry?
For sure. Seems like a really great jumping off point. A lot of what the SEC has said over the past decade as it relates to digital assets mirrors quite a bit what they look at when you think of more traditional assets. And so things like investor protection, market manipulation, concerns with regulatory compliance and filings in order to have that kind of transparent look at what the average investor might be investing in are all up there as far as priorities for the SEC, specifically when it comes to enforcement. And when they've taken a look at aspects of the digital asset space, they tend to focus on things like ICOs with the initial coin offerings. And do they look like securities offerings? Are they falling under the lens of a 33 or 34 Act requirement? And then they're also looking at the cryptocurrency exchanges themselves. As you may be aware of, with the recent actions taken by the SEC against Coinbase and Binance, they're really taking a look at participants in the exchange space of this industry and looking at whether or not they are selling unregistered securities, operating as an unregistered broker, or combining a lot of functions that we normally like to see spread out between different players and operating at an arm's length basis. And then on top of that, you have kind of the traditional concerns with cybersecurity, as well as things like AML compliance. If you recall, in the early days when Bitcoin was making waves, a lot of government officials were concerned with Bitcoin being used as a way to circumvent AML controls or allow sanctioned investors to invest in things that they shouldn't be allowed to and move money around on behest of some really shady organizations. So that's always been a concern for the SEC, and that's definitely come out in the past decade of enforcement actions as well.
Points. So it's a related question for Josh. So, speaking of, some of these concerns that the SEC has And then thinking across a global context, and both of you have a pretty global background, so you may both have some thoughts there. But Josh, what do you think about kind of how the SEC's concerns are similar or different from some of the other major regulators around the globe? I think in particular, for example, thinking through EU and European regulation with MiCA upcoming, as well as some of the regulatory progress, as well as concerns that have been happening, for example, in Hong Kong, China, et cetera.
So thanks. So that's a pretty broad question. I guess the way I would first start to address it is to say, I agree with what Philip said. And I think some of what the SEC focuses on, right, is disclosure and also conflicts of interest, right, for their investor protection emphasis, which is one of their twin prongs, right? They also have capital formation, which sometimes seems to be getting lost a little bit, if I do say so. And I think, though, this concern about disclosure and self-dealing or conflicts of interest, I think that's probably pretty common across regulators. There's just a different, and across the globe, I would say, probably things like MiCA, which is meant to address, having good markets, right? And I think this kind of transparency and this kind of understanding that we want to have market integrity, I think that probably flows across a lot of nations, perhaps not all, right? And there are different types of setups, different types of regimes in the world. But I think that the SEC does have in common. Now, its way of addressing it often is quite different. This is because, and this comes up all the time in practice with my colleagues, because sitting in different jurisdictions, we may be advising a client. It could be a bank, it could be any type of entity or a person, right? And we could say, okay, so in Switzerland, we think we're pretty comfortable that this fits into this category. And in the UK, we're comfortable with this. And in Singapore, we're comfortable with this. And in the US, we always have to say, well, wait, how was it offered? How was it marketed? How was it sold? It's really a different set of questions that are being asked. And I think that's where a lot of the differences are coming in. And that's why I think the industry, in many ways, although we do have a large body of relevant case law, depending on which way you argue it, right? SEC is arguing it one way, and certainly those in industry often are arguing it a different way. But contrast that with other jurisdictions that may have more bespoke legislation or bespoke, other types of sandboxes or other situations where the industry may say, oh, that looks a lot more clear. That has a lot more certainty.
That makes sense. I think, yes, most of us want better markets. Yeah, that's I think something we can agree on. Well, so to Josh's point, Philip, if we're talking about some of these changes that the SEC, if the stance of the SEC continues to gain traction within the US, where do you see this for other jurisdictions, and where do you see this potentially for the broader blockchain and cryptocurrency market in terms of I guess if we continue to go down this road in the US, what will the potential impact be globally is the basic question.
For sure. I think one of the first main considerations that you have to take into account here is that everywhere else in the world, regardless of what they think about it, watches what happens in the United States. Globally, the SEC is probably one of the most powerful regulators on earth because it regulates investments and transactions in the world's most powerful economy. In private markets, something that we see all the time is, regardless of where in the world you are, when you're wanting to tap into the largest market where capital is available for investment, you come to the United States, and then Europe and the EEA is secondary to that.
Excuse me for quick interrupting. I have Don Cutts in the waiting room. Should I admit him?
So Don was for the next panel.
Okay,
yes, was promptly there, so that's good.
Sorry.
Please continue, Philip.
Sure. So whichever direction the SEC ends up taking, and not just the SEC, but also in terms of commodities, the CFTC, and then in terms of criminal investigations, what their Department of Justice ends up doing, that's going to have repercussions worldwide, because people are going to look to the United States, look to what that body of law developed as, and go, okay, this is what they're doing in America. This is either what we need to mirror if we want to get that type of investor in our products or that type of investor in our industry, or this is what we need to do differently if we want to take those who might be excluded in the United States or feel pressure in the United States and bring them into our industries instead. And that's where you get kind of the second point, which is markets, I think, that are going to look at attracting the same type of investor, the same type of business, the same type of portfolio holdings are going to want to mirror what's happening in the United States and may not be as aggressive at setting their own rules, but more responsive in terms of what they first see happening in the United States, and then they develop their own laws accordingly, versus market participants who really want to differentiate themselves from the United States and maybe scoop up the people left out of what's going on with American markets. They're going to be looking to be more proactive and more inviting, whereas US markets may stymie that a little bit because of the regulations.
Yeah, that's an interesting point about where things will happen in terms of our potential arbitrage country by country versus potential kind of leader follower scenario. So it might be a bit of both depending on the jurisdictions. So, well, and Josh, to Philip's point about here's what we need to be doing differently, I think that's a question that, to kind of turn it to the opposite side of the spectrum, I think a lot of people in blockchain like to talk about what they think the regulators should be doing differently, but ultimately this is a two-way street. So Josh, you're in the kind of the trenches here of working with a lot of blockchain companies on some of these organizations that you've mentioned. What do you think are some of the top things that people in the blockchain industry need to do differently versus on the regulatory side?
Sure. Actually, is it okay if before I answer that, I just tag something on to what Philip said from before?
Go for it.
Okay, so I think as we think about some of the globally harmonized laws or the overarching laws that are being talked about, whether it's recommendations from the FSB, the Financial Stability Board, right, or IOSCO, or when we have the G20 heads of state, and there's going to be an IMF FSB report for that. We have to remember, like Philip was saying, our US regulators play a huge role in those. And if you actually look at the most recent FSB reports, some of them echo things that the SEC has been saying, including concerns about market participants playing multiple roles and potentially having conflicts of interest. That was actually in one of the explicit recommendations focused on that. And I think it's important to note, the IOSCO report that's in the works, right? My understanding is that folks from the SEC are actually the lead drafters of that. So just as we think about, it rotates for different things, but I think it's going to focus on DeFi. That's my understanding, right? But as we think about what's happening throughout the world, I think just as Philip said, yes, you can stay out of the US. We can help you as practitioners, to stay out of the US somehow. But the US does have not just an extraterritorial reach, but also just a reach of influence. And some of the influence you might not even realize is being influenced. So I would say in terms of what the industry should be doing, I think it really depends on whom you talk to. Right, I have to answer this a bit delicately, right? Because there are some of us who are lawyers advising clients on, okay, here's what you should do. Here's what we think the regulator thinks, right? And if you want to stay out of the regulatory crosshairs, here's what we would recommend you do, okay? And so that may involve, in certain instances, if you're going to do a capital raise, most likely, if it's going to involve a token, not legal advice, not investment advice. These are our personal views. This probably applies to all of us, but it's highly likely that I'm going to say that looks like a securities transaction to the SEC, and therefore likely we should treat it as a securities transaction. Now, if you are in a different stance, right? Say you're a litigator and you've got a case right before you, you may be taking a different tactic because at that point, you already are in the regulatory crosshairs. And there you're looking to say, what can I prove in court, right? What can I get a judge to agree with? What do I have the strength of, of the historic cases? Or where can I say, as folks are doing now, actually, SEC, this question is something that Congress is focused on, right? And not the SEC. So I think these are very different kinds of questions. And then, of course, there's other questions about how should we, as an industry, be communicating with and trying to, educate and request action by legislators. So I would say on that latter point, certainly there are lots of efforts right now to mobilize folks, and there has been great outreach by the industry to legislators. I would say in the other two instances, seek good counsel, right? That's probably the number one piece of advice that I would have for the industry is this is complicated stuff. Things are being decided day by day, and the cases that we see in the headlines, whether it's involving trading platforms or issuers of digital assets, whatever it is, each decision at each stage of these cases, whether it motion to dismiss or summary judgment or some other interlocutory appeal, just to name a few different things we've seen, all of these are having an immediate potential effect on all of the other cases. That's why I think staying close to, I'm not doing this as a plug for lawyers, but I think it is important as we've seen the ground shifting under our feet, even over the past few weeks, that you seek legal advice.
Makes sense. Well, and so thinking through, what players in the blockchain space can be doing to kind of adapt to regulatory shifts. Philip, wondering what your perspective is, from the kind of large institutional side, for example, Chase and other kind of institutional banking players. Where do you see some of these kind of the bigger dogs here making adjustments or potentially kind of preparing to make adjustments in reaction to what's been happening on the regulatory stage over the last few months?
Yeah, so kind of as Josh was saying, one of the curses to having a common law legal system is that things aren't prescribed in stone, set in stone, that everybody can just look at, flip to a certain page and find an automatic answer for everything under the sun. It doesn't work that way. And because financial markets dealing with digital assets is something that's relatively new when you compare it to traditional finance, the law isn't really settled in this area yet. I mean, you even have July of this year when the Ripple case, when the initial order in that from the district court came out, basically blowing apart the SEC's whole case, except for one point that looked a lot like traditional finance. And then you had everybody at Coinbase and Binance celebrating, even though you had another judge in the, I'm blanking on the case now. But there was another case decided.
Labs, SEC,
yes, exactly. Where the judge came out and said, I get that this ruling came out, but I don't think it's right. And it's setting itself up for interjurisdictional contradictions, which automatically get escalated on appeal. And then that'll allow potentially a circuit split, which then has to go to the Supreme Court. And then you're looking at Howey 2.0. So it's really one of these instances where what the law isn't known to the regulator, it's not known to the courts, and therefore it's not known to the market. It could be this, it might be that, it looks like something else. And that's why it's very important that when you're positioning yourself either as an investor, as an issuer of digital assets, as a financial services company that might look into offering digital assets to your clients, that you're really paying attention to the developments in the space and appropriately marking those risk factors in any type of offering materials that you're providing. Something that catches a lot of people off guard is when they're not appropriately disclosing the risks for an emerging market trend, something shocks that market, and then your investors come back to you and go, well, you never warned me about this. You never said that this was a possibility. You never told me the law wasn't settled or that the regulator would pull a total 180 and start coming after us. These were all material concerns that I would have not given you my money for had I known. And so even from just a business relationship standpoint and a professional reputation standpoint, you want to make sure that in any type of offering materials as a digital asset provider that you are providing to potential investors, to potential partners, to potential sponsors, that you're disclosing these risks appropriately and that you yourself are staying on top of that, whether that's engaging competent legal counsel, whether that's engaging public policy monitors, whether that's making sure you're reading the financial press, that you understand that this is a dynamic space and things are changing daily. So you can't just say, this is the direction I'm going to steer the boat in, and we're never going to adjust course, because you might just be running straight into an iceberg.
Gotta avoid those icebergs. So you mentioned Howey 2.0, which I think is a really interesting concept. So, I mean, I, for one, would say, I like to say that that crypto, digital assets are special, just like any other asset class, where ultimately, there are very specific considerations in blockchain and crypto, just like there are, specific considerations in real estate or in securities or treasuries. But at the end of the day, they are all assets, potential financial instruments, et cetera. So, but to that point, so thinking through a potential Howey 2.0 and what that might look like, I mean, just looking at kind of the environment from which the Howey test was birthed, really looking at almost 100 years ago, some of this regulation that started to kind of set in motion in the wake of the Great Depression. So how much of this, and it's probably would be great for both of you to weigh in. Let's start with Josh. How much of this do you think is going to stay the same versus where do you see kind of a 2.0 what would the term be, update, let's say, where would you see potential areas where an update might be needed?
Wow. So I think if I just give a little framing, so there have been cases after Howey, right? Like people often say Howey and its progeny, right? So that's why we're sometimes like saying solely
son of Howey.
Really, yeah, exactly. Okay. Based on the efforts, right? We have had refinements over time. And so I think to the extent that this does become a circuit split, or it does otherwise end up at the Supreme Court, I think this, to the extent it is Howey 2.0, I think it would be potentially focused on one of the questions that's on a lot of people's minds, which is whether the investment contract is embodied in the token, as the SEC is arguing, or whether the investment contract is kind of this sleeve through which the token arm goes, right? And it's a sort of weird analogy, but that's how I'm envisioning it right now. And I think that that's something where, if it were to be decided at the Supreme Court level, if we look at, for example, Coinbase's motion for judgment on the pleadings, I think we can sort of see the ideas taking shape. For example, there's a focus on this idea that, guess what? Although the Ripple court, Judge Torres had rejected Ripple's argument about an essential elements test, right? They said Howey doesn't say that, right? That's an additional thing. What Coinbase has argued actually is that's part of Howey, right? The requirement for the written contract, that's part of Howey. And they cite to things like Black's Law Dictionary, saying that a scheme is a document, right? And taking account of some of the language of Judge Rakoff in the Terraform Labs Do Kwon judgment that came out for the motion to dismiss, which was declined, right? Which was denied. And so I think that is a place where I think there will be a lot of focus, is this idea of, number one, can you have an investment contract without a writing between the parties? And number two, okay, so you have an investment contract. Is that the offer and sale and marketing, right? And not embodied in the token? I think that's something that many, many reasonable minds disagree on right now. The SEC and some out. Yeah.
Interesting. And Philip, what do you think on that note of the kind of Howey and its progeny?
Yeah, so I mean, this isn't as much of an answer as it is throwing another question into the mix. But when Judge Torres kind of issued the ruling in the Ripple case, they expressly declined to talk about secondary sales. And that's huge, because in the securities business, initial offerings are almost always followed with a secondary offering, whether you're talking in the public market space and even in private markets, like private investment funds. The market for secondary sales of securities is huge. So if we already have courts that are trying to establish this is what it looks like in an initial offering, but this in no way touches on what it looks like for a secondary sale, that's just another question that isn't being covered right now, but that is a huge element to the market. Because how are you supposed to market, assuming that you're marketing a security, how are you supposed to market a security to investors and tell them, your access point to liquidity here could be a secondary sale, but we don't know? That's not a lot of confidence. That's not going to excite people to buy into something. So even apart from the initial considerations defining further, is the investment contract a scheme that must be in writing? And then you throw the questions into the mix. Does that depend if both parties are sophisticated parties versus one is a sophisticated party and the other is just a layman consumer? These are all the types of questions that have to be answered, and nobody really has any good answers for it yet. We can look at, again, to traditional finance and Howey and his progeny and try to piece together some best educated guesses, but nobody really knows the answer yet. So until we have more established case law and judges repeatedly articulating what they believe a test might be or what the elements should be when it comes to digital assets, it's still going to operate in this kind of amorphous gray zone where you can disclaim the risks, but that's really where the light stops. And then we're getting into maybe territory.
Wow, so many more, almost more questions than answers coming from this, but that's, I think, in the spirit of where this is headed, is that there's a lot that's going to need to be addressed in the US and in the world at large. We're at time, but just briefly, maybe you could both any last words that either of you want to mention. Maybe we can start with Josh.
Sure, thanks. And this actually tees off well from what Philip was just saying about marketing. One thing that I just think it's important to emphasize before we go is that even say the ruling in Ripple stands, right, about the primary sales on trading platforms not being sales of securities. Some people in the market were saying, oh, that means we can market however we want, right? Because we're not doing an ICO, but we have to remember there are existing laws and there are a world of laws about marketing, right? Number one, can't commit fraud, whether it's a commodity, whether it's a security, otherwise can't commit fraud. Also, consumer protection laws, also state securities laws and other laws. Also, other countries like the UK has a marketing law relating to crypto that can result in jail time of up to 2 years in certain instances. Not a UK way to say, and the rest of the world as well. Just please, as you do see rulings come down, again, seek legal counsel, because sometimes we may want to construe things more narrowly than we might hope.
Makes sense. Philip, how about you?
I completely agree. It's one of those things where we are still in the dynamic market period of what this legal regime might shake out to be. So I think really disclosure is your best protection at this point. As long as there is a reasonable paper trail that marks what the risks are, what you've been doing in response to rulings or statements from regulators, and making sure that you're vetting those with counsel, with your experts in the space, and making sure that your investors understand this is what's happening. We don't have clear answers, but this is what we're doing in the spirit of transparency, in the spirit of providing information, and in the spirit of trying to stay on the regulators' good sides. That's as best as you can do right now to really have that surefire way to not end up in court going, well, we didn't know what we were doing. We were just selling something, which is never going to win you a day in court. So staying close to your attorneys, staying close to the people interacting with the regulators, and then keeping a pulse on what happens in the courts and what are being stated by these regulatory agencies, especially with as much movement as we have going on in the space right now. It cannot be understated how critically important that is going to be for at least the next 5, possibly 10 years, until we start having repeated precedents being handed out and clarifying where the buck stops in this industry.
Makes sense. Well, again, thank you both so much for taking the time to join. I have learned a lot of things and also started asking a lot of questions. So this was really, really informative.